If you are.
Yeah. Joint Legislative Audit and Review Commission will come to order. I've been asked to pinch hit. Senator Howell's not feeling 100% this afternoon and asked me to fill in. I think she just felt sorry that this might be the last chance I'll get to chair for at least 2 years. But anyway, so I don't know. But with that, good to see everybody. Welcome to the new digs, as it were. I made an observational, a moment of observation this morning at the earlier meeting. There are no clocks in this room. But that being said, I've got one. So we're still going to try and keep trains on track and running on time, and we'll try and go from there. Is there any business to come before we go ahead and get right on the program? Already, Hal, if you would, please.
Thank you, Mr. Chairman, and members of the commission, welcome. I'm Hal Greer, the staff director of JLARC. Mr. Chairman, we have 5 items on the agenda this afternoon. First, Senator McPike will report on the work of the topic selection subcommittee. Next, JLARC staff will present our biennial report on JLARC impacts. We'll then present our report on attorneys. You'll also then receive a status update on VITA, and we have the state's chief information officer with us today. And finally, we'll present our annual report on economic development incentives. Mr. Chairman, first up is the subcommittee report.
Thank you, Mr. Chairman. The topic subcommittee met prior to our last meeting on October 16th, had, I think, a healthy discussion on a number of different issues. In your packet is a list of the proposed resolutions. Mr. Chairman, there are 2 items that will need some additional work for our December meeting, one of which being the data center discussion that the topic committee had. There's some additional language that staff is going to be working through. There's a number of different complex things that require sort of additional follow-through on that topic. And so that item, Mr. Chairman, will be deferred to December. And additionally, Mr. Chairman, the higher education and cost efficiency will be deferring that item until December for additional work on the resolution language to make sure staff has the right direction. And with that, we'll do a quick brief on the resolution topic items from staff.
I just go through the topics real quickly, and if there's questions that members have about the topics, we'd be happy to address those. But there's something in your packet, and just going in order, the first one was looking at access to broadband across the Commonwealth. There was some good discussion about the amount of funding that has been provided for that and how complex it is to do that well. Senator McPike mentioned the interest in data centers, and we're working on the specific language around that topic, but that's something that there was interest in tolling and traffic congestion reduction, specifically kind of along the I-95 corridor, but also definitely the I-81 corridor. Senator McPike also mentioned the higher education cost efficiency one, which had its genesis in a resolution that was referred over to JLARC. There's some interest in continuing to refine that language. One thing I would point out is there was a staff idea to look into state government modernization. And when we kind of after the subcommittee meeting thought about the bandwidth that we had, we think we can kind of make some progress on that topic perhaps in the back part of next year. So there's a resolution in there that reflects that basic topic, particularly focused on information technology projects and the use of kind of modern IT project techniques. But that would be, I think, a topic that could maybe be several reports and something that we would work on next year as we had staff availability. Another resolution that was referred was transferring the Department of Juvenile Justice over into the HHR Secretariat. So we have a resolution for you on that. And then one specifically looking into the VCU health system governance. There's some specific things about that system in terms of how it's operating and how it's governed that are in that resolution, if you're interested in looking at that. And the last one would be a review of the Department of Health. A lot of things in terms of the pandemic response, the challenges that presented to them, the leadership changes, how important that is as an organization, how large it is as an organization. So resolution is in your packet for that as well. I went through that very quickly. I apologize. But if there's questions, we'll be happy to answer.
The members? Discussion. This coming from a subcommittee does not require a second. We can just take action on the matter pending before us. There's discussion on the motion to adopt the study resolution proposal for the coming work year.
Yeah, Mr. Chairman,
Yes, sir, Senator McPike.
I appreciate staff's work on it, and I think the topic committee had some pretty healthy discussion, especially around the tolling and traffic congestion. We have different parts and component all around the state, but getting a Commonwealth-wide idea of what's going on and lessons learned is really important. And of course, the broadband expansion across the Commonwealth, getting those reports. Just want to highlight those two that have, I think, particular interest as it impacts all parts of the Commonwealth. And move the adoption with the exception of, obviously, the data center resolution and the higher education cost efficiency study.
That motion is properly before us. Discussion on the motion on adopting this is the work plan for the coming 2024 year for the commission. If no discussion, all those in favor signify by saying aye. Aye. All opposed, nay. Unanimously adopted. Thank you, Senator McPike and members of the study subcommittee. Hal, next item. We're ahead of schedule. I'm just
We're
saying.
running ahead so far. So far, so good. Mr. Chairman, the next item on the agenda is the JLARC biennial report to the General Assembly. We're required by statute to report at least once every 2 years on actions taken in response to prior reports and recommendations, and to bring to your attention matters that may require follow-up. We typically provide this report in May every 2 years, but with a later budget timeline this year, we could not complete it until this fall. Also, you may recall that it is practice to bring to you a related report to you each fall on unimplemented recommendations that we have entitled Recommendations for Legislative Action. So you've gotten both of these reports in your materials, the JLARC Impacts, which is basically our biennial report, and then the Recommendations for Legislative Action. We're essentially combining both of these reports in today's presentation. Most of the biennial report is devoted to an update on actions taken by the General Assembly and agencies over the last 2 years to implement JLARC recommendations. The report also covers cost savings achieved and actions still needed to implement key recommendations. In assessing how JLARC is doing with the impact as well as savings, JLARC staff maintain performance measures that we present every 2 years as part of this report. I will share our performance on these measures in a moment. Then Justin Brown and Tracy Smith will highlight some of the significant actions taken during the last 2 years to implement JLARC recommendations. And then finally, I'll address legislative actions still needed to implement key recommendations. Now to the performance measures. Slide 4 shows key performance measure for assessing the impact of JLARC work. It indicates the percentage of recommendations implemented from reports published over the last 4 years. As you can see, follow-through on the implementation of recommendations has been very good. Of the recommendations that we've issued over that time period, more than 2/3 have been partially or fully implemented. Much of that credit for the strong follow-through goes to members of this commission as well as the broader General Assembly. As part of our mission to improve efficiency and other key performance measures, the amount of savings that result from JLARC recommendations. Savings over the last 2 years are due to VETA implementing a process to automatically collect financial penalties from IT infrastructure suppliers that don't comply with contractual requirements. Estimated savings are about $10 million over 2 years. A final performance measure that I'll briefly mention is legislation introduced based on JLARC recommendations. During the 22 and 23 sessions, a total of 77 bills and 66 budget amendments were introduced to implement JLARC recommendations. With that, Mr. Chairman, I'd like to turn it over to our Associate Directors to briefly highlight significant legislative and agency actions taken over the last 2 years that have been implemented key JLARC recommendations. First up is Senior Associate Director Justin Brown. Justin?
Afternoon, Justin.
Afternoon, Mr. Chair. So, as many of you probably remember, when we looked at the impact of the pandemic on K-12, one of the major things that teachers and students themselves agreed was a big area of need was student mental health. And 2 statutory changes were made to begin the process of helping address those needs. The first was a bill patroned by Delegate Wilt and Senator McPike. It allowed licensed clinical psychologists to be provisionally licensed to serve as school psychologists. The second bill was patroned by Senator McPike and Delegate Rasool. It more clearly defined direct counseling so that counselors in school can spend more of their time working with students and less time on other activities such as monitoring lunch or recess. And finally, in the area of K-12, as we all know, there's a big drop in student learning during the pandemic, and we had a variety of recommendations to help address that, including to specifically focus on math remediation. And this year's budget included about $400 million for schools to help catch kids up who fell behind during the pandemic. Another area where there's been significant follow-through was the juvenile justice system. We looked at the juvenile justice system back in 2021, and since that time, the department has moved out on some things that will shore up some of the gaps we found in the system. For example, they've started to improve what they do to help youth who are on probation. This includes creating a workforce program unit that specifically focuses on giving job training in high-demand skills areas. It also includes doing a variety of things to improve the statewide quality assurance function in the probation area. Another thing to highlight is that the department has tightened up how it thinks about its guidelines that govern how long they keep youth in custody. There's now a multi-level review of the decision to release youth and requirements to be met, including related to treatment progress prior to being released. Last thing I'd highlight is in the transportation area. This goes back a little while ago, but the high inflation was making the out-year costs for big projects even more expensive. So the CTB accelerated its revenue sharing allocation time frame from what used to be 5 or 6 years out and brought it forward to 3 or 4 years out. So that's helped to kind of mitigate the impact of the labor materials price inflation, particularly on big projects. So now I will turn it over to Tracy to talk about some other areas of impact.
Questions of Justin?
Oh, sorry.
Tracy, welcome.
Thank you, Mr. Chairman. Good afternoon, everyone. The first topic that I'd like to cover is our report of guardianship and conservatorship, which we completed in 2021. The legislature implemented several recommendations from that study in the 2022 session, and then again this year. This year, 5 bills passed, including one that was sponsored by Senator McPike to improve the guardianship system. The bills establish a requirement for how often guardians actually visit the adults who are under their care, require courts to hold hearings to periodically determine, whether anything about the guardianship arrangement needs to be changed, and that would include whether the adult should even continue to have a guardian. The bills also prevent guardians from restricting the ability of adults under conservatorship to communicate with others. And then finally, legislation passed to require various entities, including financial institutions, to provide information to the court that is relevant to the guardianship proceeding. Mr. Chairman, another study that legislators acted on was our study of the behavioral health services that are delivered by the state's community services boards. The Behavioral Health Commission took up many of our report's recommendations and introduced legislation as well as budget amendments to implement them. Their efforts will result in increased salaries for CSB staff, expanded community-based behavioral health crisis services, which should not only improve Virginians' access to needed services, but also reduce the pressure on the state's mental health hospital system. The legislation also established for the first time in state law a clear purpose for CSB services and required DBHDS to set goals and objectives for CSB's service delivery. And finally, the legislation required DBHDS to improve the contracts that it has with each CSB to enhance the state's ability to enforce the provisions of those contracts and to set conditions for CSB's receipt of state funds. Finally, Mr. Chairman, the legislature took action to implement several of the recommendations from our 2021 Affordable Housing Study. These bills were carried by Delegate Carr, Delegate Ware, and Senator Locke. Delegate Carr's and Senator Locke's legislation required DHCD to assess the state's affordable housing needs every 5 years and to use that assessment to create and maintain a statewide plan to improve the affordability of housing across the Commonwealth. Delegate Ware's legislation will give the state insight that it has never had into the policies that localities have adopted that might affect the development of affordable housing, such as zoning changes. And then additionally, VHDA, now known as Virginia Housing, also took actions on our report. Their board made changes to its methodology for determining how much of its assets it should contribute to its REACH program. REACH is the state's largest discretionary fund for affordable housing. And Virginia Housing, their board also modified its committee structure to improve their focus on the authority's finances, its internal audit function, as well as the CEO's compensation. Finally, Mr. Chairman, 2 bills implement recommendations from our 2021 report on trade and transportation incentives, which was overseen by Kimberly Sarte. The legislation will improve the design of Virginia's port incentives. Mr. Chairman, that's all I had to share with you this morning.
Any questions?
This afternoon.
All right, thank you, Tracy.
I'll turn it over to Hal now, and he'll talk about our unimplemented recommendations.
Thanks, Tracy. Mr. Chairman, one final area of impact is VITA. When we present the VITA update later in this agenda, we'll briefly highlight some of the positive impacts from our work there. I'd now like to take a few minutes to highlight a number of key recommendations directed to the General Assembly that staff consider to be the most significant of the legislative recommendations that remain unimplemented. Given time constraints, I'm going to move through these fairly quickly, but I'm happy to stop for questions, and we're happy to work with any members who are interested in introducing legislation to implement any of them. We have several recommendations in the education area that I'll highlight first. In our 2022 report on the impact of the pandemic on K through 12, one of the actions we concluded that would be most beneficial to school teachers and students would be to provide temporary funding for more instructional assistance, to assist teachers with providing tailored small group and individualized instruction, and to help teachers manage behavioral challenges in their classrooms. We continue to believe that this will be a valuable investment by the state and provide great benefit to our teachers and students at a relatively low cost. In our 2020 review of the Department of Education, we concluded that it is critically important for DOE to maintain a high-quality school improvement office for the purpose of providing needed assistance to struggling school divisions and schools. We continue to believe that the General Assembly needs to make clear through statute that this vital role is a priority and that DOE should be directed by statute to implement a high-quality school improvement program and regularly evaluate its effectiveness. In our review of the Children's Services Act in 2020, we found that Virginia has more children placed in private day schools to receive special education services than most other states, and these schools are a more restrictive environment. We concluded that CSA funds need to be available to serve more children in their public schools and less in private day schools, and that control of the CSA funds currently reserved for private day placements needs to be transferred to the Department of Education so that some of the funds currently used for private day placements can be provided to school divisions to serve more of these children in their schools. Continuing with education, we found through our review of dual enrollment that many school divisions and community colleges are imposing an unwarranted cost burden on high school students by charging tuition for dual enrollment classes, even though general fund appropriations pay for the cost of these courses. We had several recommendations to reduce the dual enrollment cost burden on students. First and foremost, we recommended that the General Assembly direct school divisions to provide dual enrollment courses at no charge to economically disadvantaged students. We further recommended that the General Assembly appropriate funds to pay for the expenses associated with dual enrollment classes for economically disadvantaged students. And then finally, we recommended that school divisions and community colleges be prohibited from charging dual enrollment tuition for any high school students as long as the general fund appropriations cover the cost. Finally, in the education area, Mr. Chairman, you may recall that we conducted a review of financial assistance for higher education last year. One of the findings was that students who are attending college part-time, often because they also need to work to support themselves, do not qualify to receive financial assistance through the Virginia Guaranteed Assistance Program. Part-time status should not disqualify a student from receiving financial aid, and we recommended that the General Assembly authorize part-time enrolled students to receive prorated financial aid awards. Mr. Chairman, as you just heard, a number of recommendations have been implemented from our CSB study last year, but key recommendations remain unimplemented. The review found significant staff vacancies and high turnover were substantially hindering the provision of behavioral health services. Our review concluded that it was vital for the state to more closely monitor staffing in the CSBs, and to do so, the Department of Behavioral Health should be required to report at least annually on salaries, turnover, and vacancies by position type. The CSB review also found that many who were screened to determine whether they met the criteria for temporary detention and therefore hospitalization in a psychiatric hospital were inappropriately placed in a hospital based on the TDO determination because pre-admission screeners at CSBs are not sufficiently trained or overseen. We recommended that the General Assembly direct that the Department of Behavioral Health partner with institutions of higher education to provide better training and technical assistance to CSB pre-screeners to reduce the number of individuals inappropriately hospitalized. Our review of CSBs also found that CSBs are not maximizing their federal Medicaid reimbursements. Medicaid billing is more complicated than it needs to be and currently requires CSBs to work with 6 different MCOs in the state that all have different processes. This should be addressed by directing the Department of Medical Assistance Services to work with the MCOs to standardize the policies, procedures, and requirements that CSBs must follow to obtain Medicaid reimbursements. This is something that can be done and frankly should have already been done, but apparently DMAS is going to need to be given clear direction from the General Assembly to make it happen. Finally, the CSB review found that the process to search for beds for patients that have been placed under a temporary detention order is cumbersome, slow, and inefficient. The Department of Behavioral Health needs to be directed to develop a near-term solution to allow CSBs to more efficiently share patient documents within patient psychiatric facilities so that precious time is not unnecessarily wasted in searching for beds for patients under a TDO. As discussed earlier, there have been several actions taken to implement recommendations from the 2021 review of affordable housing. However, there remain key recommendations that have not been. The study found that there's very little transparency around Virginia Housing's resources to enable affordable community housing program, referred to as the REACH program, which is the state's largest source of discretionary funds to expand affordable housing access. We recommended that the program's transparency be greatly increased and that Virginia Housing be required to report annually to the General Assembly on contributions to REACH, the fund's balance, expenditures from the fund, and the impacts of those expenditures to increase accountability. As part of the housing study, JLARC also found that local zoning ordinances, especially in the state's fastest growing localities, often are a significant impediment to the development of affordable housing. Our review concluded that one of the only potential ways to address this challenging impediment is to provide localities with an incentive to establish more favorable zoning policies. Therefore, we recommended that the Department of Housing and Community Development be directed to develop an incentive program that will help to encourage local affordable housing zoning policies. Delegate Carr introduced legislation last session to implement this recommendation. We continue to think that this makes sense as an approach to address the affordable housing challenge. Mr. Chairman, while the General Assembly has already acted on many of the recommendations from our guardianship report in 2021, as reported earlier, there remain significant unimplemented recommendations. Our review found that guardians ad litem are required to report very little information to judges about the primary candidate under consideration to serve as a guardian, and no information on the suitability of other individuals who have expressed interest in serving as the guardian. To better ensure that judges are making informed and good decisions in the appointment of guardians, and if those selected are qualified and capable, we recommended that guardians ad litem be required to provide substantially more information in reports to the court about the candidates to serve in this role. Also, with regard to guardianship, we found that more safeguards need to be put in place to protect these vulnerable individuals in need of guardianship from financial or other harm. We recommended that the definition of self-dealing be expanded in the code to apply to actions taken by guardians and conservators to the financial detriment of those being served by guardians. That the assets inventory of adults under consideration for guardianship be made transparent to better ensure protection of those assets, and that guardians be required to notify designated contacts of changes in conditions or circumstances of individuals under guardianship. There's currently no such requirement in place. And finally, Mr. Chairman, as part of our review of the transportation infrastructure and funding in 2021, we found that the state could more efficiently and economically maintain its bridges by allowing funding from the State of Good Repair program to be used to repair bridges that are in fair condition, rather than waiting for bridges to become structurally deficient. Addressing bridge maintenance sooner can be critical to allow the bridges to be repaired before they're at a point where they need to be fully replaced, which is substantially more costly. Our review recommended that the code be amended to provide for the use of good repair funds to repair bridges while they're still in fair condition, which will improve safety and reduce costs. Senator McPike patroned legislation last session that would have implemented this recommendation, and it passed both houses, but it was vetoed by the governor. Mr. Chairman, that concludes that whirlwind presentation. Again, we'd be happy to work with any members who wish to introduce legislation to address any of these recommendations, and I'd be glad to answer any questions that any members may have about any of these.
Any members have questions? All right, thank you, Hal.
All right, Mr. Chairman, the next item on the agenda is a review of the state system to provide attorneys to indigent defendants. We also looked at Commonwealth attorneys and several aspects of the pretrial process. I'd like to thank several groups who helped us on this study. Early on, we determined that judges were uniquely qualified and positioned to evaluate the quality of defense provided by public defenders, court-appointed attorneys, and privately retained attorneys. I want to thank the more than 300 judges statewide who took the time to complete a survey for us. Their responses provided invaluable insights and are a core part of the findings we have for you this morning. I also want to thank Maria Jankowski and her staff at the Indigent Defense Commission. They were extremely helpful and accessible and worked closely with us on a variety of research activities, including an effort to measure attorney workload. And finally, I'd like to thank Carl Haid and his staff at the Office of the Executive Secretary of the Supreme Court. They provide us with a tremendous amount of data that we have used for much of our analysis. I'll turn it over now to Justin Brown, who supervised the study. Justin?
Just real quick before I bring up Joe, I'd like to highlight two things. First, we were asked to look into the feasibility of two ways to change the pretrial process, both of which were in legislation referred to JLARC as part of this project. Delegate Carr was one of the patrons, and Delegate Scott introduced a very similar bill in 2020. I just want to say that the pretrial process is very complicated to understand and evaluate. There's a lot of variation across the state in how pretrial processes work right now, so requiring major changes in all localities would be really challenging. But we did identify a series of things that you can do to help interested localities move closer and further in the direction of quicker resolution of the pretrial process when appropriate. And I'd also just like to brag on our staff for a minute. We felt to properly assess the indigent defense system, we needed to have an analytically based way to measure the impact that the type of defense counsel can have on case outcomes. So Hal said we interviewed and surveyed judges, which we did do, and it was incredibly informative. But we also analyzed more than 4 million court records over a 10-year period using statistical regression techniques to determine what factors do influence a variety of case outcomes. To our knowledge, this analysis to quantifiably measure the quality of attorney representation hasn't been done before in Virginia or even nationally, and it was a major, major undertaking by this team and tough to pull off, but I am proud of them for doing that. So with that, I'd like to bring up Joe McMahon to give you the details of the study.
Good morning, Mr. Chairman, members of the Commission. As Justin said, my name is Joe McMahon, and I'll be presenting our report on indigent criminal defense and Commonwealth's attorneys. Working with me on this study were Brittany Utz, Kate Agnelli, Scarlett Saunders, and Madison McCaffrey. Brittany will also be stepping to the podium to present a few of the topics during this presentation. So, for this study, we were asked to assess the adequacy of legal representation for indigent defendants, determine how many attorneys are needed statewide for prosecution and for indigent defense, look at attorney compensation, and evaluate potential changes to the pretrial process. Here's the main research activities. Hal and Justin already highlighted probably the two most notable ones, that comprehensive court data analysis and the survey of judges, where we heard back from 300 of them to get their opinion on the quality of representation they see attorneys providing in their courtroom and strategies to address issues in the indigent defense system. Our key findings are that court-appointed defense attorneys and public defenders generally provide effective counsel to indigent defendants. Fewer attorneys are willing to serve in a court-appointed defense role, primarily because of low payment from the state. More Commonwealth's attorney positions would help offices more effectively handle their workload. And public defender workload has increased, and many public defender positions have been vacant, exacerbating workload concerns, but recent recruiting efforts have helped. First, for some background, and I'll pause on the end of each section like we normally do for questions. Like I said, for some background. Prosecutors and defense attorneys each play a vital role in the adversarial legal system. That's the premise that a vigorous prosecution and defense overseen by an impartial judge will result in a fair and just outcome across criminal cases. To accomplish this, we need enough prosecutors and defense attorneys with the time and ability to represent the state's and the defendant's interests. Another key point, the state has a constitutional obligation to provide defense counsel to indigent defendants. The U.S. Constitution guarantees the right to an attorney for the accused when life or liberty is at stake, and when someone can't afford an attorney, they must be provided one by the public. Virginia has a hybrid system of attorneys for indigent defense. Last year, the state relied on 2,000 private attorneys to work as court-appointed defense counsel. They are used in localities without a public defender, if the public defender has a conflict of interest, or if specialization is needed. On the other hand, the state has 28 public defender offices overseen by the Virginia Indigent Defense Commission that are allocated 430 attorney positions statewide. Overall, the state spent $127 million on those two groups combined in FY23. Here's the 28 public defender offices and the 56 localities they serve. On the prosecution side, Virginia has 120 Commonwealth's attorney offices. Commonwealth's attorneys are elected constitutional officers, and most employ other attorneys and support staff. For this presentation, we'll use Commonwealth's attorney to describe both the elected attorney and the assistant attorneys making up their staff. Those attorneys prosecute felonies and have discretion to prosecute misdemeanors. The entire system received $84 million in state appropriation last year, with at least $50 million more in local funds to supplement state salaries or to employ additional staff. I can pause there for questions.
Joe, I had one quick question.
Sure.
On slide 9. How are those 28 public defender offices determined?
Simple answer as it has to be placed into code which localities have an office. So over time, since the system was developed, it's been kind of an ad hoc approach. As you see, they tend to be centered in population centers to get the higher caseload, but there are some in rural parts of the state. Hey, moving on to case outcomes for indigent defense. A key point here is that indigent defendants are entitled to effective representation from their state-provided attorney, and that is a right that is established by the United States Supreme Court. As a quick aside leading into these findings, we looked at millions of court outcomes for criminal charges over 10 years. Some of this analysis encompasses 4.4 million charges. This analysis looks at court outcomes by the type of attorney providing the defense in the aggregate. There may be individual defendants or individual attorneys whose experiences differ from these broader trends, but our mandate was to examine the adequacy of representation system-wide. So with that, the analysis shows that there's no evidence that the type of defense attorney substantially affects case results, and judges report court-appointed attorneys and public defenders both provide quality representation overall. So first, there is little or no systemic difference in how charges were resolved by attorney type during the past 10 years when comparing court-appointed attorneys, public defenders, and privately retained counsel hired by defendants. So first, we'll look at the proportion of charges that resulted in a conviction. If the type of attorney greatly affects whether a charge will result in a conviction, you'd expect to see the portion of that line, or the portion of the bar to the right of the line, to be much different across the different attorney types. But what you see here is that the percent of charges leading conviction was similar for defendants being represented by each category. Likewise, this next measure is the proportion of charges that were reduced from a felony to a misdemeanor. You'll see that there are only marginal differences by attorney type. Next, we found no quantifiable evidence that attorney type affects how cases were resolved during the last 10 years. That means pretty much an equal likelihood of charges being resolved in a plea versus going to trial. Not pictured here, but similar results were also found for sentence lengths received for charges that had a conviction. And this finding is more than just the data. A majority of judges reported that the quality representation they see from court-appointed attorneys and public defenders in their courtroom is good or excellent overall. I can pause there for questions.
Sorry, Mr. Chairman. Thank you. If you can go back one slide, I'm just interested that the description of the judge's consideration of the quality representation. The seems to be a fairly significant delta in the excellence category of a public defender than court-appointed. Can you speak to that a little bit? That seems to be a pretty significant departure.
Yeah, I would agree with that conclusion. I think overall we did hear that, as you can see here, from the judge's perspective statewide, the public defenders did perform a little bit better overall in their opinion. And I think part of that is just, it's termed the zealousness of defense, and the thought being that the public defenders, because they're full-time staff dedicated to that, rather than a private attorney kind of handling this with a wider caseload, are sometimes able to spend a little bit more time or put a little more effort on these cases. But I do want to make the point that that is not to say they felt the court-appointed attorneys were failing in any way. And a lot even said those court-appointed attorneys look similar to when they're serving in a retained role. But at the top line, I would agree with your conclusion.
Further questions? Thank you, Joe.
Okay. Next, I'll move on to Commonwealth's attorney staffing. Commonwealth's attorneys are staff to the local elected constitutional officer, but they receive state funding based on staffing allocations and salaries set by the Compensation Board, pending approval by the General Assembly. An important effort took place this year. The Comp Board contracted with the National Center for State Courts to do a detailed study of how Commonwealth's attorneys spend their time. The results of that effort are being used to guide the board's future Commonwealth's attorney staffing allocations and budget requests, referred to as staffing standards. The main finding here is that new staffing standards suggest more Commonwealth's attorneys' staff are needed to handle their workload. The current Commonwealth's attorney staffing allocation is sufficient to handle 87% of the workload to prosecute felonies system-wide. To fully meet that felony prosecution workload, the state would need to allocate an additional 112 attorney positions. That represents a 15% increase to the current 728 state-funded attorneys at an estimated cost of $9.2 million annually. Currently, about 6.5% of those allocated attorney positions are vacant. However, just filling those vacant positions would not be enough to meet the workload demands. It would address less than 1/2 of the unmet felony prosecution workload. And probably more importantly, nearly 3/4 of the offices don't have a single vacancy, many of which have an unmet workload. So even when fully staffed to their current number of allocated positions, they still have some of that unmet workload. I can pause there. Okay, I will move on to court-appointed defense attorneys. So court-appointed defense attorneys are private attorneys paid by the state to provide representation to indigent criminal defendants, and they're an integral part of the state's indigent defense system. They defended 54% of the charges for which the state provided representation, and, as mentioned earlier, they handle all cases in localities without a public defender and a portion of cases in localities with a public defender. Our first finding is that fewer attorneys are serving in the role of court-appointed defense. The decline has occurred over the past decade, but has recently accelerated. Nearly 4,000 attorneys served in 2013 compared to just 1,900 this past year. Half of judges reported that it is challenging or very challenging to find an attorney to appoint for criminal cases. Most judges have indicated it has gotten more difficult in the past 2 years. You can see these quotes. Courts are calling many lawyers before they find one to take a case, and the few remaining attorneys are often too busy to take on new cases. Along with that, judges in some parts of the state say the lack of court-appointed attorneys is hindering court operations. Having too few court-appointed attorneys reduces court efficiency because court staff need more time to find an attorney to serve, and the attorneys have more schedule conflicts, which makes it more difficult to schedule hearings. This not only affects court efficiency, but it also has implications for the defendant's right to a speedy trial. In addition, the state has potential legal exposure if indigent defendants can't be given an attorney, and other states have faced lawsuits on those grounds. You can see here, judges pointed to that lack of attorneys for delays. Again, anytime we show these quotes, this is a sample of many that looked similar to those. Low compensation for court-appointed attorneys, primarily due to caps set in statute, are cited as the primary reason for the decline. Virginia has an hourly pay rate of $90 for court-appointed attorneys. That rate is set by the Supreme Court, and we found it to be comparable to rates used in other states. In addition, there are pay caps set in statute, which are maximum payment amounts based on the type of charge being handled. And those pay caps are where the main problem lies. They result in attorneys working substantial time for which they are not paid on a typical case. JLARC worked with the National Center for State Courts to establish estimates of the average amount of time it takes for a defense attorney to provide adequate representation for different types of criminal charges. According to those time estimates, the average time an attorney needs to provide representation for a violent felony is about 25 hours. But the current pay cap is set to 13.7 hours of work for a Class II felony. That means that any time worked over 13.7 hours would not be compensated. Likewise, just 1.3 hours would be compensated of the typical 10 hours required for defending a juvenile charge and the typical 6.5 hours required for defending a misdemeanor DWI. You should note that attorneys can request a supplemental waiver form for pay for some additional time above the cap. However, that amount is modest, requires additional approval, and it isn't always available because the supplements are subject to a finite amount of funding, which often runs out prior to the conclusion of the fiscal year. Low payment was overwhelmingly cited as the reason fewer attorneys take court-appointed work. We conducted a survey of current and former court-appointed attorneys and asked them about a dozen different factors influencing their decision to serve. The results were very clear. 89% of attorneys who stopped serving cited compensation as a top factor. Likewise, 91% who said they were considering taking fewer cases or leaving service altogether cited compensation. And then for good measure, on the judges' survey, 94% of the judges cited raising compensation as one of the top ways to address concerns with the indigent defense system. So to meaningfully impact the number of attorneys willing to serve as court-appointed defense, pay caps should be raised to better reflect the time attorneys spend working on cases. That means that certain approaches to addressing the caps are not advisable. These include having no pay caps, which puts the state at risk for large payments and a greater fiscal impact, as well as setting pay caps without an analytical basis, such as uniformly raising them all. The analytical basis that should be used is the average time a defense attorney in Virginia spends on a case. And that leads us to our first recommendation. That's to amend the code to set higher pay caps for court-appointed criminal defense attorneys. To go along with this, if pay caps are increased, the offense categories corresponding to each cap should also be changed. They should be changed so caps more closely align with the time spent by attorneys on each type of offense. The current categorization means that pay caps often do not align with the workload associated with each type of charge within the same category. We heard this from the attorneys themselves, and we saw in the data from the study of case times. For example, violent felonies and DWI are two primary areas where this is the case. So we recommend that if the General Assembly increases pay caps, it should also consider categorizing offenses into these 5 groups for the purpose of setting those pay caps. And finally, the amount of additional compensation to attorneys and the fiscal impact to the state would depend on the extent to which caps are raised. Pay caps could be raised for all types of charges or to target certain categories. They could also be set to different levels of the amount of time compensated. So using misdemeanor DWI as an example here, setting the cap to 75% of the average time an attorney spends working on a charge would require it to be raised from the current $120 to nearly $450. Setting it to 100% of the average time would mean a cap of about $600. On page 28 and 29 of the written report, we lay out some example scenarios for increasing pay caps to varying degrees. I'll focus on just a couple of those here. They range from scenario 1, which is a relatively modest increase by setting pay caps equal to 75% of time an attorney typically spends working on charges, and targeting the 3 categories of charges that currently have the greatest disparity between the average attorney time and amount paid. At the other end of the range is scenario 5, which assumes raising the caps for all charge types and setting them to compensate up to the full 100% of the average time spent by attorneys. As you'd expect, the fiscal impact to the state would depend on which caps were raised and by how much. Here's the estimated new spending for each of those scenarios on the previous slide, with that first scenario I described being the lowest cost and the 5th scenario being the highest. I can pause there for questions. I'm going to turn it over to Brittany for the next 2 sections.
Senator.
Before he leaves,
Sure.
I don't know much in the area of the practice of law, but I know more than a casual amount about this particular area of the law. The question I have is, before my editorial comment, is in the preparation and analysis, was there a meeting held with the criminal law section of the Virginia State Bar to get the input from that group?
Senator Norman, we talked to the criminal law, it was the association. Of the state bar, I'm not sure. We did receive input from over a dozen court-appointed attorneys, people serving that capacity through the various associations and groups. And then our survey went out to about 1,600 of them.
Mr. Chairman, knowing a little bit about this, in case you are not aware that the cost of personnel has gone up dramatically all across this country since the pandemic, and law firms have not been immune to that. And so when someone takes a court-appointed, say as a sole practitioner, takes a court-appointed case and he's paid $125, that's probably not going to even cover his support staff, but there's some other things going on. You find a lot of younger attorneys who are coming to practice who will start out on the court-appointed list because it gives them an opportunity to gain experience, and the financial factors are not quite as pressing. But those who develop a certain degree of expertise, and I don't mean self-anointed expertise, I mean they develop an expertise, they rotate out because they've gotten that initial experience and they can move into a sector representing criminal defendants where they can charge more. Another phenomena that you see that would not necessarily be reflected in the statistical analysis you've done is it is remarkable how individuals that may initially say that they are indigent, when they find out that they are confronted with a very serious crime, they are less enthusiastic about a court-appointed attorney than retaining an experienced attorney who may have a higher degree of expertise. So sometimes the confrontation of the consequences will move criminal defendants away from some of those serious cases. Another phenomena is that major law firms, while they do a lot of pro bono work in various areas, the level of enthusiasm is not at a feverish pitch when it comes to the criminal cases, because you get into larger law firms where individuals develop certain degrees of expertise, and that's a factor. Another thing that's a factor, and we did address it a little bit a couple of years ago when the Commonwealth Attorneys Association approached the General Assembly, and that was when there was an increased use in body cams. And I can tell you, you can spend enormous hours going over body cams, and they can be from the dashboard of a police vehicle cruiser to every incidental to an arrest. And because of some of the societal changes, body cams are being used more and more. And I mean, I have spent 15 to 20 hours just going over body cams and dashboard cams, and you are looking for a variety of things. Another phenomena that I've seen, just because I get around a fair amount of the state and practicing this kind of law, but particularly in Hampton Roads, it's remarkable when I see an attorney on a court-appointed list, say from the peninsula, and I go to Virginia Beach to try a case, and I see that same attorney on the court-appointed list in Virginia Beach. Why do I mention that? Well, the relaxed ride from, say, Williamsburg to Virginia Beach, depending on the day, can be anywhere from an hour and a half to 3.5 hours. But you see that there is a cadre of those attorneys that are moving from jurisdiction to jurisdiction. I don't say that critically. Actually, I applaud them for their willingness to do that. But if you look at it objectively, it suggests that perhaps there are some financial factors or other factors that are in it. So I appreciate my soliloquy and you listening to it, but it is an area I know a little bit about.
Senator Norman, I jotted down a few notes. Yeah, we would concur with most of almost, I think, everything you said from what we heard in interviews. One point is one of the big motivators behind potentially raising these pay caps is keeping those as attorneys as they gain more experience in that court-appointed role, so make a little bit less of a stepping stone. Definitely the body-worn cameras, and we talk about that for what that means both for prosecution and defense as far as workload, especially on like the DWI charge being an example of 2 or 3 officers respond, each with an hour body-worn camera. All of a sudden, you've already spent all your time up to that cap watching footage. And then, yes, just a few attorneys with a big workload, meaning if the state can attract more into this world of court-appointed, that's probably better for everybody.
Joe, of course you concur with the senator. Senator Sproul.
Thank you, Mr. Chairman. The question was asked earlier about had you consulted with the Bar Association? And I was listening to what he was saying. I knew you were talking about court-appointed lawyers and so forth, but not the Bar Association. And I thought maybe in the Hampton Roads that I knew about the Bar Association, when I meet with them as a group, they weigh in pretty heavily on decision on whatever they're trying to do. So I was concerned with that. And the second question, Senator Norman was talking about a gentleman who lives at Newport News sometime could take an hour and a half or more to get to Virginia Beach. And so I'm not being a lawyer, so I want to know if that person whom he was talking about, they get paid more for handling a criminal case. I know I'm saying it wrong, versus another type of case. So I'm saying they should get paid more. So I'm just curious that why was there not enough discussion with those bar associations? You got 2 or 3 more Hampton Roads and bar associations. They really should have weighed in on what it should be on different levels. And that was bothering me that you talk with lawyers, you talk with judges, not association. And that should have been done. I think they can really be helpful on each category, each level on what it should be.
Senator Sproul, yes. And we did talk to a sample of local bar associations, and we talked to the Virginia State Bar several times as the course of this study. To the exact localities that I have to go back and look at our interview history there. But I said with the survey and with some of our other interviews, we reached out to hundreds of court-appointed attorneys in one way or the other. So those opinions from Hampton Roads would have been hopefully captured sufficiently there. And then about the commute piece, that transportation time, when you're billing it, should not be billed to a case. You can file for reimbursement for mileage, but that's a whole separate process, whereas the time spent per case is what they're billing for the court-appointed work.
And we had in Chesapeake,
Senator Spiro, I would say that I think falls in the line. What we were hearing from judges that the just lack of people doing this, so then a smaller number of attorneys covering a bigger area. And yeah, whether mistaken or not, it's an impact on courtroom efficiency, and trying to bring more people into this area of defense is going to benefit both the defendants, the attorneys, and the courts.
All right, thank you, Joe.
Okay. I said I'm going to turn it over to Brittany for the next few sections.
All right. Brittany, welcome.
Good afternoon, Mr. Chairman and members of the Commission. As Joe said, my name is Brittany Utz, and I was the lead analyst for the public defender portion of our study. I'm going to walk through our findings related to public defenders as well as attorney salaries. In addition to court-appointed attorneys, public defenders play a critical role in the state's indigent defense system. Public defenders are state employees who receive state-funded salaries and benefits. They defended 46% of the charges for which the state provided representation in FY22. After a period of relatively low vacancies across the state, the number of vacant public defender attorney positions began to increase in FY20. A combination of additional attorney positions being allocated to the system, workforce challenges, and a difficult hiring environment exacerbated by the COVID-19 pandemic resulted in a statewide vacancy rate of 24% in FY21. However, VIDC has consolidated its recruitment efforts in recent years to staff in the central office, and as of October 2023, the public defender attorney vacancy rate has declined to 8% statewide. For our first finding in this section, we estimated that public defender workload has increased substantially in recent years. First, the total number of cases handled by public defenders has declined from about 100,000 cases in FY13 to about 76,000 cases in FY22. However, in working with the National Center for State Courts, we found that the amount of time estimated necessary to provide quality representation for different types of criminal cases has increased over the past decade. Across different case types, the amount of time estimated to be necessary per case has increased by an average of 70%. This increase in workload is attributable to several factors, most notably a proliferation of electronic evidence, such as body-worn camera footage and social media, all of which attorneys are ethically obligated to review. This increase in workload has affected public defender offices to varying extents, depending on the numbers and types of cases handled by each office. From FY13 to FY22, public defender workload is estimated to have increased by an average of 47% across offices. Because of the increase in workload, we also found that an imbalance between the amount of work the system needs to handle and the number of attorneys available can hinder the quality of public defender representation and court operations. On a JLARC staff survey, many public defenders reported that they only sometimes, rarely, or never have time for some activities that could be important for a case, such as conducting legal research or identifying and interviewing potential witnesses. Judges also expressed concern that high workloads can impact the quality of public defender representation and decrease courtroom efficiency. Additionally, nearly 1/4 of public defender offices had to pause accepting cases for at least 4 weeks during the past year because of insufficient staffing. We also found that only half of public defenders reported having sufficient support staff to provide quality representation to their clients. Support staff assist attorneys with various administrative and case-related tasks, which can help to mitigate their workload. However, because of limited funding, most offices only have a single position for each type of support staff. Particularly for large offices, as shown here in the table, staff that support a high number of attorneys must prioritize which attorneys and cases to assist. The National Association for Public Defense recommends a ratio of 4 attorneys to 1 paralegal, and the statewide average across public defender offices is currently 13 attorneys for every 1 paralegal. Mitigation specialists also have similarly high ratios of attorneys to support staff across offices. Providing additional funding to increase the number of support staff in public defender offices could be a relatively cost-effective way to lessen attorney workload. Support staff can help to free up attorney time to devote to other case-related work, and chief public defenders report that it's generally easier to fill these positions. Support staff also have lower average salaries than attorneys and are therefore less costly to employ. Therefore, we have a recommendation in our report for the General Assembly to consider funding additional mitigation specialist and paralegal positions to help lessen public defender attorney workload. As part of this study, we were also asked to consider the need for expanding the public defender system and found that adding more attorney positions or opening new offices can be longer-term considerations for the state. Even with additional support staff, there are currently not enough attorneys system-wide to sufficiently handle public defender workload. If all 430 allocated positions were filled, the public defender system would only have enough attorneys to handle about 87% of its workload. Therefore, after the full impacts of recent salary increases and recruitment efforts on the attorney workforce are clear, it may be necessary to reevaluate the total number of positions allocated to the public defender system. Expansion of the system could also be considered at that point. Appendix H of the final report includes additional information about key considerations for expanding coverage as well as example staffing calculations. Mr. Chair, I'll pause in case there are questions.
Yes, sir, Delegate.
So we saw about the support staff, the lack there, but then, if I'm understanding, on slide 56, you're proposing to increase the number of attorneys. Do we feel that that's the best use of personnel and funds and so forth? I mean, would we not be better to increase the number of support staff?
Delegate Wilt, that's a good question. I think because the public defender system had recently had a lot of difficulty filling its vacant positions and is only starting to make a dent in those, the thought of adding additional attorney positions didn't seem like the best course of action in the near term because we wanted to give them a chance to be able to fill the positions that they already had, which is why we recommended adding additional support staff positions because they can help to mitigate some of that attorney workload. But because the system has improved its vacancy rate sort of in the beginning of fiscal year FY24, to the extent that they're able to fill their existing positions, we suggest that it might be helpful at that point to sort of reevaluate how many attorneys that the system would need, because ultimately attorneys are who you need to take cases and go to the hearings in the courtrooms and things like that. There's only so much that support staff can do. So once they're able to fill their existing positions, we would suggest reevaluating the number of attorneys at that point.
Mr.
Further
Chairman.
questions? Senator.
Thank you very much. I'm looking at that slide 52 where it's showing the number of attorneys in 4 major jurisdictions in Virginia where they have 1 paralegal. That is appalling. And the reason I say that, if you do not even have an administrative assistant that you can have making phone calls or issuing witness subpoenas or helping prepare appropriate pleadings, that's going to run up the attorney's time tremendously. And I say it, I was very fortunate. I had a full-time paralegal who knew more than most attorneys in this area of the law on it. But the amount of work that she could handle and take away from my desk and consume my time was an efficiency. But also, you probably haven't thought about this, is that many of the clients that I represent on these kind of cases knew that she was a go-to person that they had comfort with in talking, and that she would communicate whatever that client may have shared with her to me, and establishing that relationship and that confidence is so important. But 1 paralegal in Fairfax is disgraceful. Just in case you're wondering.
Further questions? Brittany, if I may, to kind of follow up on that, and also looking at slide 47, I can't help but think, being the non-lawyer, but I still can't help but think, to Senator Norman's point, that a court-appointed representative who's a private attorney that's been appointed, or one who has been privately retained, probably has more paralegals in their practice and therefore is not devoting as much of their own personal time. Did anything in y'all's research show that the extra hours of work that the attorney was doing was the same if it was a retained attorney or an appointed attorney?
Mr. Chairman, what I can say in response to that question is that these particular numbers on slide 47 include only attorney time. So this does not include any administrative tasks that support staff would be doing. You can, and studies have been done previously looking at the amount of time support staff spend for each type of case, but that was not something that we did
And I
as
guess
part
to
of the
follow up
study.
on Senator Norman and also Delegate Wilt, I mean, that's kind of my point, that if we have more paralegals there, we're going to have less billable time to the actual attorney, because the paralegal is doing more of the grunt work, the leg work, things of that nature. So that sounds, just financially the best path forward for the short term at least. Okay, thank you.
I think, just to clarify, I would say that per case, the amount of time spent here would not go down by adding more support staff, because the attorneys would still be spending this amount of time per case on average. And these case times are also what we used to develop the cost estimates for the court-appointed attorney cases. So the numbers are separate from any staff time that would be also contributed to the case.
Mr. Chair.
Senator.
Thank you, Mr. Chair. Slide 48, I just had one question. The unit of measure for the columns that are indicated is not clear, and also the report indicates the backup data in an Appendix D, and my copy of the report does not have an Appendix D to look at the data. So the first question is just, what is that a 6-month unit measurement across the fiscal years?
So, Senator McPike, this figure on slide 48 is showing the difference in workload minutes from FY13 to FY22 proportionally. So we took each office's amount of cases multiplied by the amount of time they should be spending on each case for the years FY13 and FY22, and then calculated the percentage change. But then the appendixes, which I believe will be online shortly after the conclusion of the meeting, Appendix D has some additional information on the contributing factors to why the amount of time spent per case has increased for both prosecution and defense. But then Appendix G also has additional information specific to public defenders and what is driving the increases by case type for the amount of time spent for each of those types of cases.
One follow-up, Mr. So this is by office, and so the one would presume the column on the right would be Winchester at 158% increase, and so this is, I don't know how many people in that office compared to a Fairfax or somewhere else.
Senator, that is a good question.
We can sidebar. It's just comparatively for a visual, it's hard to digest it as a measure of total volume of work and the indications supporting it.
The Winchester office has 13 attorneys allocated to them, and the Fairfax office has 25 attorneys. So it's about double the size. Okay, I will now turn to our section on public defender and Commonwealth attorney salaries. Compensation for these two types of attorneys can include both state and local funding. Commonwealth's attorneys are state-funded local employees whose salary is set by the Compensation Board and subject to the General Assembly's appropriation. Public defenders are state employees with salary levels set by the Virginia Indigent Defense Commission based on funding appropriated to the Commission. Statewide in FY23, state-funded salaries for both types of attorneys were around $75,000 on average. Beyond the state's base salaries, localities can also provide salary supplements to one or both types of attorneys within their jurisdiction. As you may remember, salaries for public defenders and Commonwealth's attorneys have been substantially increased in recent years. Attorneys have received several across-the-board state salary increases over the past 2 fiscal years, and the General Assembly also appropriated separate substantial funding specifically to increase salaries for these two types of attorneys. This additional funding will increase public defender salaries by an average of about $12,000 per attorney and Commonwealth attorney salaries by an average of about $11,000 per attorney. We found that these recent salary increases will likely narrow salary gaps with local government and private attorneys. In FY23, the average public defender and Commonwealth attorney salaries were lower than local government attorneys. Salaries for both attorney types were also lower than private sector attorneys within the same region of the state. However, recent steps to increase salaries will likely narrow compensation gaps with local government and private sector attorneys to some extent. Additional information on how public defender and Commonwealth's attorney salaries compare to other types of attorneys, including other state-funded attorneys, can be found in Chapter 6 of our report. Specifically in relation to local supplements, we found that supplements are generally associated with fewer vacancies across offices and account for differences between public defender and Commonwealth's attorney salaries within the same jurisdiction. The state portion of public defender and Commonwealth's attorney salaries is relatively similar, but localities generally choose to provide more supplemental funding to Commonwealth's attorneys. For example, nearly all Commonwealth's attorney offices that share a jurisdiction with a public defender office offer a local supplement, averaging about $21,000 per attorney. However, in contrast, only about half of public defender offices receive a local supplement, averaging about $15,000 per attorney in those offices. The figure on slide 64 shows how local salary supplements differ between public defenders and Commonwealth's attorneys within the same jurisdictions. For example, in Charlottesville, public defenders receive an average local supplement of about $16,000 per attorney, whereas Commonwealth's attorneys receive an average supplement of about $32,000 per attorney. For both public defenders and Commonwealth's attorneys, offices with higher local salary supplements are typically better able to recruit and retain attorneys as they have lower vacancy rates on average. Policy options 1, 2, and 3 in Chapter 6 of the final report include some targeted approaches to further address Commonwealth's attorney and public defender salaries. Mr. Chair, I'll pause again here for questions. I'll now turn the remainder of the presentation back over to Joe. Thank you.
Thank you, Mr. Chairman. 2 more short sections to go. I'll move into our work related to the pretrial process. Specifically, the study resolution asked us to evaluate 2 changes to the pretrial process. These include providing counsel at first appearance for all detained defendants and holding bail hearings on the same day as a first appearance, which is referred to as a same-day bail hearing. These policies are intended to have several benefits, including improving the quality of legal representation, helping courts more quickly decide whether to release a defendant on bail, and reducing the amount of time detained if a defendant will ultimately be released on bail. Some quick background. The pretrial process, for the purpose of this section, begins when law enforcement makes an arrest and takes a person into custody. That person has a magistrate hearing where an initial bail decision is made, which includes whether and under what conditions that person will be released. If the defendant remains detained, the person next has a first appearance where they are informed of their rights and the charges against them. They typically also have an attorney appointed to them during or after this hearing. Finally, their attorney can motion for a bail hearing where the court considers bail. In practice, the timing of that pretrial process can affect how quickly a detained defendant has a bail hearing. In some courts, that takes less time, and a first appearance and counsel appointment happens quickly and promptly leads to a bail hearing. However, in other courts, those steps take more time, resulting in a bail hearing happening days or even weeks after arrest. So these policies we're talking about would mainly apply to the 1/3 of defendants here that are still detained after 1 day following their arrest, and then within that group, specifically, those who are ultimately released on bail prior to their trial. And that's the group in the dotted line. Our 2 main findings in this area are counsel at first appearance and same-day bail hearings have benefits but face logistical impediments, and the state could take several actions to help interested localities move towards the goals of these policies. The policies would have benefits, but we found the impediments preclude requiring statewide implementation at this time. You can see the benefits encompass those that I mentioned earlier related to shorter detention, improved quality of representation, court efficiency, and lower jail costs. On the other hand, there are impediments. Notable ones include limited availability of attorneys to provide this additional counsel, and courts and attorneys having less time to prepare. In the absence of a statewide requirement, the state could take several actions to help interested localities move closer to the goals and benefits of the policies. These include allowing a defendant to complete the required forms for defense earlier, which could allow courts to appoint an attorney sooner, clarifying whether limited defense representation, in this case, having an attorney provide representation for just a first appearance or a bail hearing could reduce the potential for conflicts of interest, and clarifying that the defendant can argue for bail at both the first appearance and later at a bail hearing if needed. I won't read them, but here's the 2 recommendations and a policy option from the report that try to achieve those actions on the previous slide. I can pause there for questions.
Again, I was listening with interest, and particularly after I read the report. As you were doing your analysis, did you make any distinction between a rural jurisdiction and an urban jurisdiction? In a rural jurisdiction, they have general district court judges who may be covering 3 or 4 separate jurisdictions, whereas a more urban jurisdiction has a judge or multiple judges sitting 7 days a week, where Delegate Knight reigns supreme in Virginia Beach. They always have a duty judge, and that judge's responsibility is to deal with matters that are coming up on a short fuse. And so I asked that question, and then as you were considering this, as we yelling and screaming go into the 21st century, the opportunity to use Zoom and webcast are not uniformly applied. During the pandemic situation, for a variety of reasons, many jurisdictions, even some rural jurisdictions, were using arraignments, using bail hearings through Zoom or webcast, and the reliability of those may be subject to some conversation, but using the 21st century communication devices could solve some of these problems. And somebody gets their first bail consideration by a magistrate. Well, you're not going to have a lawyer coming into the magistrate's office at 2:14 in the morning. But then again, when they are arraigned in court, they have an opportunity to reconsider, the court to reconsider the bond. And if they don't like it there, then they can appeal it to the circuit court. So they really get 3 opportunities, but using some 21st century technology may improve that.
Yep, Senator Norman, to echo some of that, we did look at the rural versus the urban divide, and it is what you'd expect. The urban localities, especially urban localities with a public defender, because a lot of times a public defender can have a staffer there for that first appearance, is where you see that process move the most quickly. And then on the opposite side, rural localities relying solely on court-appointed defense attorneys, so there needs to be time for that person to, in those places they often make the first appearance, then they reach out to the attorney, then the attorney has to meet with the defendant. That's where you see the process drawn out. And as far as the video, use of video for this, yes, there's a lot of opportunities there. What we heard is there's a lot of implementation things to work out. This would put more stress on those Polycom systems, so more people in the court, more people in the jail trying to use it, just the capacity of the systems and the number of cameras, jail staff to help get that defendant to the camera in time. One of the funny things that, I was going into this, I was like, yeah, we could use video too. This is the future. But then there's a compelling case that now you add the attorney who needs to meet with the client and the courtroom, and now you have 3 people in different places. And so I think that's an area that has both potential but also some logistics to work out.
Mr. Chairman, there's probably someone in the room that knows better than I. But take Henrico they have a Henrico East Jail in New Kent County. It is about a 9-iron from that facility to the New Kent County courthouse. And I understand the constitutional right to confrontation and stuff, but it certainly seems like to me that there could be some reciprocity to take somebody from New Kent County all the way to Henrico, and I know what that time frame is. Doesn't make a lot of sense to me, but I think we collectively have to think outside of the box, and it's not just a criminal defense attorney against a prosecuting Commonwealth attorney. I mean, we all have a common interest in expediting justice and providing access. So I think there's some receptiveness. There's receptiveness there, just if they're given some guidance. And I'll be quiet for a while.
Moving to the final section here, I'm going to jump back to the payments to court-appointed attorneys that we discussed earlier, this time to talk about safeguarding state funds used for that purpose. We found that some payments raise questions about whether some court-appointed attorneys are handling an unreasonably high number of charges or requesting payment for an illegitimate number of hours worked. Additional safeguards are needed to ensure the integrity of attorney workload and payments. Here's a table of the 5 court-appointed attorneys receiving the greatest amount of payment from the state in FY22. For example, we found that payment to 2 court-appointed attorneys were substantially higher than the others. You can see these attorneys were each paid for over 1,400 charges that year. They requested and were paid for about 5,500 hours of work, or about 110 hours per week. While it's quite possible and common for attorneys to work more than 40 hours in a week, these unusually high numbers raise questions about whether an attorney is handling a reasonable number of charges or requesting payment for a legitimate number of hours worked. So, the state should do more to closely monitor and review and analyze individual attorney workload and hours paid. The Office of the Executive Secretary of the Supreme Court processes payment requests and maintains payment data, and therefore they should review and analyze court-appointed attorney payment requests. There would need to be criteria developed to identify attorneys whose payment requests warrant further scrutiny. At a minimum, this would include consideration of the number of charges handled and the number of hours of payment being requested. OES could flag court-appointed attorneys that meet or exceed the set criteria and notify chief judges where attorneys serve, so those judges could provide additional scrutiny to the attorney's payment request forms or reduce the number of charges being assigned to that attorney. And you'll see 2 recommendations to that effect. They include requiring the Judicial Council and the Committee on District Courts to set criteria that can be used to review payment requests, and directing OES to review those payment requests and notify chief judges of courts where the attorneys serve.
Any questions?
With that, I can conclude.
All righty, thank you, Joe.
Thank you. I'll now turn it over to Maria Jankowski, the Executive Director of the Virginia Indigent Defense Commission.
Ms. Jankowski, welcome.
Yes, I said Your Honor. I'm sorry. Mr. Chairman, members of the Commission, my name is Maria Jankowski, and I'm the Executive Director of the Virginia Indigent Defense Commission. And for those of you who are not familiar with me, although I think I've met with so many of you, we oversee the Public Defender's Office, and we also train and certify the private court-appointed attorneys. First, I want to thank JLARC. They were wonderful to work with. They were professional. They were thorough. They were objective. And I just want y'all to know that they really did fabulous work here. And we're very grateful. We feel like it captures the quality of work being done by the public defenders in Virginia. I think what's impossible to capture is our system-wide impact. We are in the communities we serve. We feel very embedded and committed to the communities we serve. And we do that in so many ways outside of the courtroom. And I think that's why you see the judges, and I'm going to go back to one of the earlier slides and brag a little bit about our work being excellent. More than anything else you saw, judges describe our work as excellent. But we don't do this alone, and I want to talk about that a little bit, but I do have my timer on, and I'm going to talk fast. We found that the drivers of our workloads are electronic, body-worn cameras, that type of evidence, but the increased number of clients with serious mental health issues and substance use disorders is another huge driver of our workloads. And I'm glad Senator Norman touched on this, and Senator Spruill, I know you know what I'm talking about. Closing facilities and moving our clients to the other side of the bay, to the other side of the river, to the Shenandoah Valley from someplace else, it is a huge workload impact on us, and I'm sure it has the same impact on the private court appointeds. But these are huge things that impact our workload. And the other thing is we have aimed to, and we've strived to provide a more holistic defense. And I think that's why you see the recommendation in the report to increase the number of mitigation specialists and paralegals in our office. Senator Norman, I agree with you. One isn't enough. I will tell you that prior to body-worn cameras, we didn't have any paralegals. We had to fight to get one paralegal in each office. That's it. Some of our offices only have one mitigation specialist. And when I took the deputy position 10 years ago, we had offices that didn't even have mitigation specialists. So in some ways, we've made some strides, but we still have a lot to go. So many of our clients, the overwhelming majority of them, suffer from mental health, substance use disorders, or either they themselves are victims of trauma, they are victims of abuse, they are victims of neglect. A lot of our mitigation specialists have social work backgrounds. These colleagues in our offices are helping our clients in so many ways. They help our clients get treatment. They help our clients get into a program. They help our clients get housing assistance. This is making a big deal in our cases. And we're able to come to court and we're able to talk to the judges. You know, I used to say there's nothing worse than a judge that won't listen or a prosecutor that won't listen. The second most frustrating thing is a judge who will listen, a prosecutor who will listen, and there's no options. There's no programs. There's no way to provide that other option other than incarceration. I will tell you that when you talk to our offices, they will tell you that the role that we need, the fastest growing need, is in these staff, these paralegal, these mitigation, because they allow the lawyers to go do the legal work while they can help address the underlying problems that bring people into the criminal legal system. And I would be remiss if I didn't say, speaking of what brings people into the criminal legal system, I implore you to consider the demand side of these increasing workloads. Every single prosecutor, every single judge, every single law enforcement officer has been in court on a case that did not need to be there. Whether it's somebody who had a mental health crisis and could have or should have received treatment instead, or whether it's two neighbors who were fighting over who cut whose bushes. And yes, we are handling those cases in criminal courts across Virginia. And that's what I'm talking about. I mean, we are dealing with stuff that shouldn't be there for a variety of different reasons. We have to look at the inflow of what's coming in, because it'll help our workloads, it'll help the judges' workloads, it'll help the prosecutors' workloads, and it'll eventually help law enforcement's workload. I'm going to quote Senator Stolley, now Sheriff Stolley, and tell you that he said, "We used to lock up the people we're afraid of. Now we lock up the people we're mad at." And I'm going to add to that the people we're concerned about. We are locking up a lot of people simply because we're concerned about them. And you don't have to take my word for it. Look at the OES data. A majority of the cases are misdemeanors. A majority of the felonies are nonviolent. And I can tell you in my experience, a lot of those are people with behavioral health issues. Less than 50% of felonies result in felony convictions. And I could go on and on about the cases that are dismissed, the cases that are no pros, the cases that are otherwise resolved. But at the end of the day, we're sitting in court on stuff that maybe, just maybe, didn't need to be there. And one thing I feel I need to point out about the report, and this is no fault of JLARC, this is no fault of OES, but was not captured in this report are not guilties. Outright full acquittals are not fully captured here, and I think it would be remiss of me if I didn't point that out, because I don't think this is insignificant, because these cases still require a lot of work. If you go to trial and a jury's out for 30 minutes and comes back with a not guilty, you got to ask yourself whether that really needed to be there. We have a lot of ideas. I have a lot of ideas about what could be done, what needs to be done, starting with real diversion. But we are ready to work with stakeholders, especially related to the compensation of court-appointed attorneys. This is a hill that we are willing to die on. We are willing to work with anybody. We have to do a report to the General Assembly every year ranking Virginia for court-appointed attorneys, and we are the lowest. It's just we are the lowest. And so I will wrap up and just say, We'll work with anybody. We've got ideas on legislation. We appreciate the funding we've received last time from the General Assembly. We're very grateful. And I'm happy to answer any questions anyone says. Yes, Senator Sproul.
Senator Sproul.
Thank you. You used the word concern. So you said we're gonna lock Sproul up. We're gonna lock Sproul up from concern. He's sitting inside Senator Lock. We're gonna lock him up because she might smack him inside the head. So explain to me when you say you lock people up, because those who you think, those who have, those who are concerned, that's what bothered me. A lot of folks saying that person should not be there. You use the term concern. Explain to me what you mean by concern as far as locking a person up because you're concerned.
So I would put it in a few different buckets. The folks at behavioral health can tell you that the number of people found incompetent and having been sent to restoration on minor offenses, misdemeanor offenses, some that are nuisance offenses, is just flooding the system. The system cannot handle the number of restorations, and a number of those restorations that we're spending money to restore people on are minor offenses. They're nuisance offenses or they're misdemeanor offenses, but yet we're arresting them. We're bringing into the system because we're concerned about them. Are they going to be safe? Are they not going to be safe? The number of people that are homeless, and then the number of people who are getting violated on pretrial because they tested positive for something. So we're locking them back up because we don't want them to hurt themselves. There's just between the mental health and between the substance use issue, we've got a whole lot of people that are in our system that don't present necessarily a danger to anyone else or an immediate, like TDO danger to themselves. But we're worried about them. And we know that if they're in the Henrico East, they're probably going to be okay. But that's a high price to pay when I think we could do better.
Senator.
And to follow on that, then those who are concerned, if you have to lock someone up because of concern, what you were just talking about, then when all said and done, you locked them up, will they end up with a record?
Depends on if they get convicted. So in some instances, we can't even get competency restored. But if they're convicted of petty larceny, trespassing, we had a disorderly conduct case that had 24 body-worn cameras for something that should not have even been an arrest. But somebody was in a bad place at a bad moment at a bad time, and so many people, Senator, plead guilty just to get it over with.
My Lord, thank you, ma'am.
Other questions? Thank you, Ms. Jankowski. Oops, I'm sorry, Delegate Will.
So, yeah, I appreciate your comments. As a non-lawyer, I'm wondering about, has any of this been reflected in things that maybe we shouldn't be charging people with in the first place? But
I'd love to be in that conversation.
Well, sure. And then another comment you made about, people in the state that they're in and so forth. But the flip side of that is, we're demanding more. We're afraid because the general society deserves to be safe.
Absolutely.
And so if we don't, we get this person's got an issue and nobody does anything and they go out and do whatever they do, who's going to be responsible for that? So, yeah, that's a question I have. But then also, Mr. Chairman, just one more, I guess, question. So, and we've had a lot of emphasis on mental health, as you stated, we've heard here today. Do we feel like the data that we've looked at, has that had adequate time for the steps that we've taken, the monies that we put into mental health care and so forth? Have we had time for that to affect these numbers?
If you want my opinion, probably not. I know that everyone's got staffing issues. CSBs have staffing issues, and so maybe not, maybe probably not. But I don't want any of my comments to suggest that I don't value public safety. And that's why I kept stressing some of the data. So many of these cases are misdemeanors. They're nonviolent cases. That's not the majority of what's going on day in and day out in our general district courts and in our circuit courts. Violent offenders are more often than not detained. And sometimes they're not, but I'm talking about everyone standing in court going, I cannot believe that we're all here on this, and that we could do better.
Thank you, Ms. Jankowski. Delegate Knight.
I remember a few years ago, Senator Norman, and I think maybe Senator Locke may have been involved in this. We had a former senator that you referenced, Sheriff Stolley, and Sheriff Stolley said the biggest number of inmates that I have mental health issues. So they put a pilot program in at Virginia Beach City Jail and allocated, I'm not sure, I think it's $900,000 or so that we put in there that identified this, and it took the people and gave them help that are in jail that didn't need to be in jail. And we also recognized that with this last budget and put another $186 million in on mental health concerns, because we need to take these folks that you talk about that are bothering us, because something's wrong with them, and you're exactly right. And we need to shift the focus from incarcerating them to get them some help. So it's taken a while for us to recognize this and to let some of these pilot programs go, but they're all working just like they were identified early on to work. So we're working in that particular direction. Some of this money hadn't taken effect yet. It just got allocated in July. But I think we recognize what you say, and I think we're moving in the right direction.
Well, I appreciate that. And I say that because I don't expect that I'm going to keep coming back to the General Assembly saying, give me more staff, give me more staff, give me. We have to address the demand side too.
All right, thank you.
Thank you very much.
Good afternoon,
Good afternoon,
Mr. Chairman.
Kimberly.
I'm Kimberly Sarte, JLARC's Associate Director for Ongoing Oversight and Fiscal Analysis. The last couple of items on today's agenda relate to JLARC's ongoing oversight responsibilities. As you may recall, JLARC has ongoing oversight of the Virginia Information Technologies Agency, or VITA. And as you may remember, we did a series of reports on VITA a few years ago for you. We have not done any in-depth reports in the past couple of years. However, we still, of course, want to keep you updated on and informed on VITA, and also the extent to which they have followed up on our prior recommendations. So next, Jamie Bitts, JLARC's Oversight Analyst, is going to give you a brief update on VITA. And then following Jamie, Mr. Robert Osmond, who is VITA's relatively new Chief Information Officer, will present you with an update. And this is actually the first time Mr. Osmond will have been before JLARC. And then finally, Mr. Chairman, Ellen Miller will be up to close out today's meeting with a brief summary of JLARC's annual review of the state's economic development incentives. Jamie?
Thank you, Kimberly. Good afternoon, Mr. Chairman. As Kimberly said, my name is Jamie Bitts, and I'm going to give you a very brief update on VITA, including their work to implement some of our recommendations in recent years. This slide just shows you the mandate for our continuing oversight of VITA, and it essentially requires us to review and evaluate VITA on an ongoing basis. Just to give you a little bit of background, VITA has two overarching responsibilities. One is providing executive branch agencies with IT infrastructure services, and that includes PCs and laptops, internet connectivity, and security services. The other responsibility is overseeing a number of agency IT operations, and that's everything from their management of IT projects to their procurement practices and their security practices. VITA's budget totals nearly $500 million in FY24, and you can see on slide 4 that the vast majority of that budget is for providing those infrastructure services to state agencies. You may remember that VITA transitioned to a multi-supplier model in 2018. That was after its contract with Northrop Grumman came to an end. It now contracts with different vendors in each of the infrastructure service areas that it provides. And as Kimberly alluded to, going back to 2019, we've provided you with 3 reports on the multi-supplier model that VITA has implemented, as well as VITA as an agency. And every report from every recommendation from those reports has, at this point, been either fully or at least partially implemented. But I'll take just a minute or two to talk about some of the key recommendations that we've made. We provided you with an update on VITA's implementation of its multi-supplier model in 2020, and we had recommendations in that report that related to improving the resolution of service incidents. Those recommendations are detailed on the slide here, and I'll just say that VITA has taken steps since then to implement all of those recommendations. We also found in our 2020 report that VITA needed to more proactively address agencies' customer concerns. Again, we had recommendations to that effect, and these are detailed again on the slide here. And since then, VITA has, again, taken steps to implement those recommendations and address customer agency concerns in a more proactive way. We also found in the 2020 report that many agencies were still dissatisfied with network services and that VITA was not routinely providing agencies with key information about the network. We had recommendations to ensure that VITA was providing better and more routine information about the network, and they are now providing monthly reports to agencies on the performance of the network for them. They're also providing, as the Appropriation Act requires, an annual report on the adequacy of the network. In 2021, we did an organizational and staffing review of VITA. One of the key findings from that report was that VITA's security staffing levels had not kept pace with their increased workload. We recommended that VITA develop a security staffing plan, which they did later that year. And the following year, the Appropriation Act provided additional funding for 9 additional security positions. And finally, Mr. Chairman, our 2021 report also found that VITA was relying heavily on contractors. We recommended that they develop guidelines for using contractors more strategically and replacing, in some cases, contractor positions with classified staff. They did develop those guidelines, and the Appropriation Act last year did provide them with the authority to convert 20 positions to classified positions. Mr. Chairman, that's everything that I'd planned to talk about. It was fairly quick, but I'm happy to answer any questions there may be.
Any questions of Jamie? Senator Norman.
Mr. Chairman, I know you'll be thrilled that JLARC will move much quicker next year. Has any, I hope that's not the case. Has any consideration been given to revisiting to allow smaller agencies to opt out of VITA? This is something that's been going on for quite some period of time. I have the privilege right now of chairing a smaller agency, and in round numbers, if they provided the same services that VITA did internally, probably be half the cost. And some of these agencies are so small that there is a disproportionate fiscal impact on it just because of the criteria that VITA has, not sacrificing any of the security or anything. But has any thought been given to that?
Senator, it's a good question. It's a comment well taken. I'm going to let Kimberly address that in terms of the extent to which we can.
Yeah. You're going to miss my good questions.
Sure, Senator. I think that is a good question. And what I can say is, since we have this, since y'all approved this modernization study, it seems like that's something that would kind of be covered by that IT umbrella when we conduct that study. So thank you for putting that on our radar.
The reason I ask that, you're probably going to see some budget amendments that I won't be here to fight for, but to increase state appropriations for providing the additional costs that VITA is charging these small agencies. And it just seems to be a fiscal, not prudent.
All right, thank you, Kimberly. Anything else? All righty. Thank you, Jamie.
Thank you, Mr. Chairman, and I'll introduce Robert Osmond, the state's Chief Information Officer.
Good afternoon, Ms. Osmond.
Mr. Chair and members of the committee, thank you so much for having me here to present VITA's story and talk about some of the work that we're doing to modernize our processes, methods, and platforms. As previously mentioned, we do 4 things. We do cybersecurity programs across the Commonwealth. We do infrastructure. We provide governance and procurement. Our agency is comprised of about 266 professionals that provide these services to the agencies that are in scope to VITA. If you look at the Commonwealth as a whole, we are a decentralized model. VITA provides core technology, we provide infrastructure, we provide cybersecurity, we provide enterprise architecture, but there are a number of exemptions outside of VITA that we do not support. We do provide some guidance and advice, but the majority of the work that's performed by agencies is really provided from an agency-specific perspective. About 2/3 of the IT spend that occurs is occurring within those agencies, and then VITA provides oversight of that spend. If you look at the scope that we provide, it's fairly extensive. Over almost 60,000 computers, a number of phone systems, the print, mailbox accounts, procurement activities, the locations, the storage, the data centers, both our private cloud as well as the public cloud. It's an extensive footprint and a very complicated environment that we are operating. We use a multi-supplier model to support that. As mentioned, it is called the MSI model. In 2018, we moved from the Northrop Grumman model, which was a sole source program, to a multi-supplier model that involved multiple contractors. We did that from a perspective of managing risk and better building and innovation. We are now in the process of modernizing and optimizing that model. In 2021, we modified our first contract, which was messaging, and then we currently have 2 contracts out for recompete. The first was our mainframe. That has closed. We're now evaluating it. And the second one is the managed cloud services. Next up, we're going to be looking at managed security services and then our data center as a whole. We are working to build out our team. We have changed our leadership team to more effectively rebalance and look at certain roles of emphasis within the organization. And we have steadily addressed the issue, notably from Mr. Bitz's recommendations on how we need to better grasp and manage our staffing levels. And we have been very effective in growing through contractor conversions, through opening new positions. A lot of these positions are cybersecurity positions. And we're currently working to build out our full team. So that work is happening every week, every month, as we look to continue to improve. Early last year, we identified what are some of the priorities that we needed to have, and we identified 7 things that we needed to work on. The first was looking at that IT customer experience. How are we looking at different agencies? The agencies are very broad. Each one offers different services, different business models. The way some of the healthcare operations, those are hospital systems, clinic systems. That's different than the way, say, public safety operates, different than the way DMV operates. And so providing support for that model requires a more nuanced approach than a one-size-fits-all. And so that is one of the things that we're working on. We are addressing a lot of the transformation activities that are happening in many of the key agencies, that they have very extensive change agendas on things they want to improve. How do we help them as their partner improve? Cybersecurity, how are we working on that to make sure that the things that are happening are being done in a safe and protected manner? It doesn't matter whether we have a breach from an agency. This is citizen data. We need to protect it. We need to make sure that Virginians are protected and that when they trust us with their data, that we take that responsibility seriously. How do we drive greater efficiency, working with data, and then transfer VITA's culture to be much more customer-centric and being much more responsive? And then the last one, applying smart governance. We do understand that sometimes there's a tendency to put in processes in place. We want to make sure those processes are in place to help rather than hinder change and innovation and progress. So with that, there are several things that we've been working on to improve. And since the start of last year, we've gotten some key programs accomplished. There's still more to be done, and we have lots of work to do for sure. One of the efforts we're proud of is the messaging migration program. We went from a Google-centric platform to an Outlook-centric platform. This work occurred over an 8-month period. We migrated over 1.6 billion objects. We worked very closely. This was the team that was involved in doing the work. It's worth mentioning that agencies provided twice that. So this was a lot of work working as a team, VITA, in partnership with the agencies to re-platform messaging. And I think that this was one of the successes we had. We had to get it right. The other thing we did was we wrapped up the data center migration from CESC, which was the legacy data center, to move out to QTS, which was our private cloud. We had to do that as well because the lease was set to expire, and we wanted to make sure we didn't have to renew that. We weren't even sure if we could. And so we were successfully able to accomplish that work and get all the workloads moved and successfully without any loss of service in the agencies that depended on these applications operating. One of the areas we've also worked very hard on is to improve our cybersecurity. You can see a lot of the things that we've done to modernize our policy in alignment with the new federal standards from NIST. We provided an enterprise approach to cybersecurity and awareness training. We've increased the security on our passwords for multi-factor and making sure that those are harder to crack. Putting in new vulnerability management tools for websites and systems, conducting stress tests. So it's not just us saying that we're pretty good, but it's really looking at external leaders like Mandiant, which is now owned by Google, having them attack our systems and validate that we have the right protocols in place to protect that Commonwealth data. And one of the things we've recognized is that this was the first year that our cyber insurance actually went down. We've bucked the trend. Our cybersecurity premiums that were negotiated by the Department of the Treasury, they did a nice job, and we saw a 20% reduction on the strength of the improvements we've made to our cybersecurity programs. Vulnerabilities has been an area of focus. We are finding more vulnerabilities. I think the software vendors are reporting more. They're aggressively patching. We do find that one of the problems that we see when you look at the bad exploits and the bad problems that are occurring out there in the general area, that a lot of them are based on vulnerabilities that were exploited. And so it looks a little bit like we're behind. The scale on the right, which is the remediation scale, is actually twice the scale on the left. So to mentally double the stacks to show some of the work that's happening. And this is work that's occurring every week as we patch, as we address these vulnerabilities that are out there and making sure that the systems that our agencies are depending on, that they are going to continue to be present when needed. And a lot of work is happening in the area of cybersecurity whole of state. In 2022, the legislation was passed for all incidents to be reported. I think that was a very important piece of legislation because when we learn about things that are happening as they happen, we're able to more effectively learn from that and address it and then replicate those countermeasures in other places. Our federal partners have put in place the state and local cybersecurity grant program. This is one of the areas we see as most vulnerable, that in many cases some of the localities and other public bodies do not necessarily have the enterprise capabilities that we have at the Commonwealth level. And so being able to help them get those capabilities so they can protect themselves is good for all Virginians. In the 22-23 time period, we did get our Virginia cybersecurity plan approved by the feds, so they're comfortable with the approach that we're taking. And now in the 23-24 time period, we are looking to disperse some of those funds and really help those localities that need it. Now, JLARC pointed out that network has been a pain point, and I absolutely agree. My background is that before I came to VITA, I was the Chief of Technology and Business Strategy for VDOT, so I definitely experienced VITA as a customer prior to coming into this current role. And network was a pain point. And so one of the things we've done is to modernize our network is to change the software basis that we use. And we're using a tool called Software Defined Wide Area Network, SD-WAN. That provides an extra layer of software to allow us to bring in redundant circuits so that local bodies and local sites can take advantage of locally available broadband that they can integrate into their existing broadband. As of about last month, we've rolled SD-WAN out to about 850 sites out of 1,000. So we've made a lot of progress, and more is happening every week. It also shows up in our numbers. What we've done is we've reduced the number of overutilized sites that are utilizing their circuits, their network. We've reduced that by half. We've doubled the amount of broadband, both broadband at the FCC level, which is 25 megabits per second, and broadband, which is the Commonwealth level. We want to get them to 100. The other thing we've done is we've optimized the network, tuned it out. Some of the applications we use are a little chatty. They like to talk to each other. And so we've looked at ways to eliminate that extraneous conversation. So we've removed about 22.5 terabytes of non-essential network traffic, which allows the important stuff to get through and the experience of our users to be much better. Website modernization. We've looked at how do we change websites. In many cases, our Virginians experience technology through these websites. We want to make sure that they know they're trusted. So we've put in putting tools to make sure that the branding bar is there, that all of the Virginian websites have a standard look and feel. We've improved accessibility so that some of our users that might experience our web programs using alternative means, that they are able to do that. So our accessible compliance scores have gone from 44% to 88.4%. We've identified over 200 websites for decommissioning to clean up some of the old websites. And we're also looking at cybersecurity to make sure that our websites can be protected. And we've removed a lot of the vulnerabilities over the last 30 days. We've seen a 50% decrease. And as we look ahead, we see a lot of opportunity. We've made some decent progress over the last 18 months. We have a lot more work to do, and we're happy to do it. One of the things we're looking to do is to productize more of our offerings so that when you productize, then there's less work designing it up front. So moving to more of a modular approach to things like applications so that multiple applications don't need to be uniquely developed in each agency. CovRamp, how do we provide assurances of third-party applications? We have close to 350 SaaS applications that are used in the agencies, making sure that they are secure. Looking at some of our cyber products to extend and help out localities and other agencies that may not be part of the mandatory VITA services, but we want to make sure they have access to the tools and technologies we can provide at the enterprise. Cloud services, making sure we're fully taking advantage of AWS, Azure, Oracle, and Google Cloud products that are out there, looking at network capabilities and identity. How do we do a better job of making sure that Virginian identities are safe, secure, and easily identifiable, easily used within the applications that they're consuming? And with that, I'm happy to conclude my presentation. Thank you so much.
Any questions? Mr. Osmond, very thorough report. As one who's just barely above flip phone and technology, I understood most of what you said, but thank you for the presentation.
Mr. Chair and committee, thank you so much for having me.
Thank you. One other item before we'll have completed our agenda. Ellen's saving the best for last. Good afternoon.
Thank you, Mr. Chairman. So again, I'm Ellen Miller, and I'll present our key findings from our 7th annual report on economic development incentives. This report includes high-level information on incentives that were awarded during the 10-year period beginning in fiscal year 13 and ending in fiscal year 22. This slide covers our mandate for the evaluations. And to briefly summarize our key findings, Virginia spent $3 billion on incentives over the 10-year period ending in fiscal year 22. incentive spending increased between fiscal year 16 and fiscal year 21, but then declined in fiscal year 22. And this is because Micron received its final large custom grant payment in fiscal year 21. And another reason is that the coal tax credits were repealed in fiscal year 21. We also found that of the economic development programs adopted since 2017, the majority have been custom grants. These are typically large and will account for a large share of incentive funding as they are paid out. Slide 4 shows how the $3 billion is distributed by type of incentive. 69% of spending was on tax incentives, and those are the two blue bars together, primarily sales and use tax exemptions. Another 30% of spending was on incentive grants, and just so you know, this amount does not include most of the spending related to custom grant awards. Most of those payments are spread out over time, with a few exceptions. Slide 5 lists the 10 largest incentives in terms of spending. By far, the largest is the data center exemption, representing nearly 1/4 of total spending on incentives. I will note that for this particular estimate, it is an underestimate, but we should have better estimates soon for the data center exemption when VDP and Tax release their first biennial report on the data center exemption. One of the recent custom grants makes this list. Again, Micron received a $70 million custom grant. This slide shows a timeline of incentives that have been adopted since 2017. And as you can see, looking at the top half of the timeline, most of these have been custom incentives for specific projects. Slide 7 shows that annual spending on economic development incentives has fluctuated somewhat over time. Spending increased each year between fiscal year 16 and fiscal year 21. And again, this is mostly because of exemptions such as the data center exemption, and also because of custom grant spending for a few large custom grants, particularly Micron. And that's why the spending amount decreases in fiscal year 22, is because Micron's payments had been paid out ending in 21, and then again the coal tax credits were repealed. The rest of my presentation focuses on grant programs because we have more information on them. Slide 8 shows that annual grant award amounts had been relatively stable until fiscal year 19, when awards increased nearly tenfold because of 3 custom grant awards totaling $830 million. And those were the grants for Amazon HQ2, Micron, and Amazon Web Services. This slide lists the 10 largest grant programs in terms of total grant awards. 4 custom grants make this list. And then the next 2 slides focus on completed grant projects. This particular slide shows that these completed projects created nearly 70,000 jobs and made nearly $17 billion in capital investments over the 10-year period. As in the past, the same 4 grant programs are on the list. VGIP and COF are the top 2 each year. And then this last slide shows that the majority of grant projects that have completed met their capital investment goal. Fewer meet their job creation and wage goals. However, since most projects receive grant funding after performance now, projects that don't meet their goals, they are either subject to no payment or reduced payment. And for those that did receive their payments up front, they are subject to clawbacks or recaptures. And with that, Mr. Chair, that concludes my prepared remarks.
Any questions of Ellen? All right, thank you, Ellen.
All right, thank you.
Sorry to make you wait so long.
Mr. Chairman, that concludes our agenda. Our next meeting is Monday, December 11th. We're back to 10 a.m. on the 11th. We'll be presenting the findings from our review of Go Virginia and state psychiatric hospitals. Thank you very much for your attention today.
All right, thank you. And for those who don't think it's lonely at the top, just look at this dais. Nobody wanted to sit in here. So, happy Thanksgiving and safe travels. We'll rise.